Ladies and gentlemen of the press, we are at the verge of issuing our statement. As you are all aware, the civil society, the media, trade unions, and other citizen groups have been under siege since the Jubilee administration came into power. And what we have seen over the last 2 years is a spirited attempt to intimidate. First of all, it started with the media. We saw it with the enactment of the Kenya Information and Communications Act. We saw it with the amendments that were introduced to the Media Council of Kenya Act. And we are aware of the hefty fines hanging over your heads, even as you seek to cover this press briefing. We are aware of the self-censorship that has been imposed on the media. And we also know that there are state intelligence officers literally camping in some of your media houses, sieving through what is covered and what does not see the light of day. And so this statement should be seen in that context, that the civil society is next on the chopping board. You are aware of the attempted amendments to the PBO Act, a law that was passed, debated by Parliament in 2012, adopted by the National Assembly as then constituted, signed into law by the immediate former President Mwai Kibaki on 14th of January 2013. You all know that that law is yet to be gazetted and is therefore yet to come into force, because the Jubilee administration prefers dealing with the civil society under the archaic NGO Coordination Act of 1990. And so this is a joint statement being issued under the stewardship of the Civil Society Organizations Reference Group and the National Civil Society Congress on the continued state of harassment and intimidation of human rights organizations, and in particular on the alleged deregistration of Muslims for Human Rights, Muhuri, Haki Africa, and the Agency for Peace and Development in the pretext of fighting terrorism. The Civil Society Organizations Reference Group and the National Civil Society Congress wish to express their concern at the manner in which the government has resorted to abuse of state machinery and its agencies to harass, intimidate, and liquidate civil society organizations in the pretext of fighting terrorism. Ever since it came into power, the Jubilee administration has never missed an opportunity to blame every challenge it has faced on the civil society in a bid to scare human rights organizations from doing their work and bludgeon them into submission. The CSO Reference Group and the National Civil Society Congress would hasten to add that it is not just the civil society that has been a victim of these acts of intimidation perpetrated by the state against its own citizens. Trade unions, independent constitutional offices, and the mass media have also become convenient scapegoats that are routinely warned, deregistered, and their accounts frozen to intentionally intimidate their boards, and their staff with a view to ultimately running them out of business. Muslims for Human Rights, Muhuri, Haki Africa, and the Agency for Peace and Development are, in our view, credible, peaceful, and popular organizations whose history and operations are above board and have over the years endeavored to operate within the confines of the law. The history of these organizations tells a story of homegrown human rights initiatives that respect the sanctity of human life, respect for the rule of law, and a commitment to peaceful coexistence among the various nationalities that live and work in Kenya generally and at the coast in particular. Muhuri's noble objective then, as it remains today, is to promote mutual acceptance and coexistence among the people of different faiths living at the coast through human rights education, advocacy, and provision of legal aid. That is the Muhuri, that is the Haki Africa, that is the Agency for Peace and Development that we know. It is in pursuit of these noble objectives that Muhuri sought and secured registration with the Non-Governmental Organizations Coordination Board in 2008, after operating as a project of the Kenya Human Rights Commission, KHRC, for 10 years. My colleague, Tom Okech, will continue with the second part of this statement.
Yes, my name is Tom Okech from the Coalition for Constitution Implementation. The Kenya Human Rights Commission is a respected human rights organization whose former and current board members have served and continue to serve this country in various capacities and could not have provided legal housing to Muhuri if its operations were not beyond reproach. Indeed, the government must be fully aware that the Chief Justice of the Republic of Kenya, Justice Dr. Willy Mutunga, the former chairperson of the Kenya National Human Rights and Equality Commission and now UN Rapporteur on Civil Rights, Mr. Maina Kiai, and the renowned University Professor of Law, Professor Makau Mutua of Buffalo State University in the United States of America, who served as chairperson of the Task Force on the Truth, Justice, and Reconciliation process, have all been associated with the KHRC at one time or the other and could not, therefore, have allowed themselves to be associated with Muhuri if the organization exposed any notions and inclinations towards terrorism as being alleged by the government. It is also not in doubt that when the government issued Muhuri with a certificate of registration in 2008, it must have done sufficient due diligence on the organization, its history, and objects for which it had been formed, and satisfied itself that its application for registration had met all legal requirements as provided in the relevant laws. It is against this backdrop that a recent government letter to the boards of Muhuri, Haki Africa, and the Agency for Peace and Development to show cause why the organization should not be deregistered point to a well-crafted and coordinated state operation not informed by the rule of law and other tenets of justice as protected under the Constitution, but actuated by outright malice and witch hunt. It is regrettable that a government that was the first to be elected under the Constitution of Kenya 2010 should act in a manner that reduces the very Constitution it swore to uphold. Article 20 of the Constitution provides that the Bill of Rights applies to all and binds all state organs and all persons. Such law and state organs include the Non-Governmental Organizations Coordination Act of 1990 and its board. Despite the clarity of this provision, an application filed by Haki Africa 1 year ago has not been processed to date. The NGO Coordination Board has not even deemed it appropriate to furnish the applicants with an explanation as to why it has not registered the organization. And as if these acts of intimidation, framing, and unlawful harassment of the organization are not enough, the government has gone as far as setting the Kenya Revenue Authority, insurance companies, and the non-governmental organizations board against the 3 human rights organizations.
Good morning. As you heard, my name is Regina Opondo. I work for CRECO, and I also co-chair the Civil Society Reference Group. So I will continue to read from page 3. Initial accusations of being sympathetic to terrorism have now turned into tax evasion and failure to update the NGO board with changes in the boards of governors and of the affected organizations. The NGO Coordination Board, that should be an independent regulator, has turned out to be the most willing accomplice in these undemocratic and unconstitutional acts against civil society organizations whose only fault is their firm stand against extrajudicial killings in the coast that the government seems to be implicated in. One of the programs that Muhuri runs, and has been running for years, is the provision of legal aid at the Shanzu Law Court for all Kenyans who wanted to access that service, and at the High Court in Mombasa. It is the position of the CSO Reference Group and the National Civil Society Congress that these interventions do not in any way constitute sympathy and support for acts of terrorism. We therefore urge Kenyan authorities to facilitate a positive working environment for NGOs by, number 1, ending the punitive administrative actions against Haki Africa and Muhuri; 2, unfreezing their bank accounts; 3, removing both organizations from the list of alleged terrorism supporters, especially since no evidence has been found so far; 4, allowing Haki Africa to continue either as a program of Haki Center or permitting it to register, as its registration has been pending for over a year, as a separate organization; and ensuring that the regulation of civil society organizations in Kenya is carried out in accordance with the Kenya Constitution of 2010. And Kenya's obligations to respect of freedom of association under international human rights law. Those of us here present believe that allowing a free and independent media and creating an enabling environment for a robust, vibrant, open, and eternally vigilant civil society are an integral part of the society that the national values and principles of governance as elaborated in Article 10 of the Constitution demands of all Kenyans, whether in government, whether in private or public life. The government cannot be an exception and should lead from the front in the realization of these ideals. For the umpteenth time, and as officials of the affected organizations have repeatedly done before, we join other Kenyans who genuinely believe in the rule of law, as espoused in the Constitution, equality and freedom from discrimination, freedom of conscience, religion, belief and opinion, freedom of expression, freedom of the media, access to information, and freedom of association in challenging the government to charge officials of the affected organizations as provided in the Penal Code with any act of terrorism, if indeed it has evidence that they engage in such acts. We, as we sit here before you, are not yet convinced that these acts of intimidation to afflict the severest pain and suffering on innocent Kenyans who are now suffering without the services of these organizations, and as such demand that those responsible for these acts of harassment, framing, and intimidation cease their unlawful actions forthwith. And that is the statement of the Civil Society Reference Group and the National Civil Society Congress.